All right, folks, good evening. I did a mistake and I did a double posting of a video. And somewhere along the lines, it appears that I've lost the first video from Module 4 dealing with civil liberties. So let me go ahead and reshoot this tonight before I get into some new things. And please, y'all, accept my humblest apologies on this for being a little bit late and duplicative. I don't even know if that's a word, but you get the idea. Civil rights and civil liberties. Y'all, it's really easy to use these two terms interchangeably, but it's really not the right way to go. Civil rights and civil liberties are two different things. And honestly, it really deals with the role of the government that's going to be involved in this. Okay. So when we just finished up that first scenario paper, y'all, we were dealing with freedom of religion. We were dealing with one of the freedoms, y'all, that are actually found in the Bill of Rights. And if you think about the Bill of Rights, I know we've talked about this, but you've got freedom of religion and freedom of speech and the press and the right to petition and the right to assemble. You've got guns in there. You've got no quartering of troops, no unreasonable searches and seizures, no self-incrimination, the right to a jury trial, and we could go on and on with these. Well, I bring this up to you because when you think about this idea of civil liberties, if you remember, the anti-federalists pushed very hard to make sure that there were certain rights, in fact, that government could not abridge. That's what the Bill of Rights are. The Bill of Rights is basically saying, look, just because the Constitution doesn't say that you can do this, it doesn't mean that you, government, might not think that you can. So we're going to pass the Bill of Rights and we are going to protect civil liberties. These are things, government, that you cannot abridge. You can't take away that freedom of religion. You can't take away that freedom of speech. You can't take away that right to bear arms. You can't have unreasonable searches and seizures. But I know it's not an absolute no. I mean, there are some exceptions. But for the bulk of the time, these are inviolable rights, privileges that we've got, the Bill of Rights and civil liberties. So these are things that government actively cannot take away. Now, when you think about civil rights, this is actually a little bit different. And I want you to think about your group identification for just a second. My group identification, here I am, I'm a middle-aged white guy. I'm just a middle-aged white guy. And your group identification, depending upon what it is that you see or you think when you're considering yourself. I mean, that could be race, that could be age, that could be gender, that could be religion. We could go on and on. But the idea is that what your group identification is oftentimes defined, or at least it should be defined by you. Now, let's just say, I'm a middle-aged white guy. Okay, we're going to talk about some of the privileges that are inherent in our system. You could argue that as a middle-aged white guy, upper middle-aged white guy maybe, I'm the person that benefits the most from the biases in the system. And maybe if you're a different gender or a different orientation, maybe if you're a different race, maybe if you're a different age, maybe if you're a different religion or non-religion, well, maybe the idea is that your group identification puts you maybe more in a sacrificed position than my group identifications put me. You see what I'm saying? Now, I bring this up to you because, y'all, if you really sit down and you really, really think about this, basically what we're saying here is civil rights is the idea that regardless of who or what you are, regardless of what your group identification is, that in fact government is going to act actively in order to make sure that you've got equal rights, that you're going to be treated the same by the system. So again, let me make sure that I'm being clear on this. Civil liberties are certain rights and privileges that government cannot take away. Civil rights are standards of treatment that government must actively be acting to enforce, to preserve, to enhance these kinds of things. So when you think about this, part of this is going to be a difference in the actual liberty versus the right. But part of this, y'all, is going to be in the actual difference in terms of government involvement. Now, if I focus most specifically on federalism, y'all, as we kick this in today, I do want you to think about this for just a second. You know, a lot of people will say, and we would probably talk more about this in a state and local government class, but a lot of people would say that the federal constitution is nothing more than what was already written in the state constitutions at the time. Let me say that again. The federal constitution is nothing more than what was already written in the state constitutions at the time. So, as crazy maybe as this might be, when we talk about the idea in terms of civil liberties, that there are certain rights and privileges that government cannot take away, we are talking about the federal government, and we're talking about violations by the federal government alone. Okay. So what I'm saying is that if the state of North Carolina or the Commonwealth of Pennsylvania or good old Oklahoma back in the day would have actually stepped on people's freedom of speech or freedom of press, you couldn't sue under the Bill of Rights because the Bill of Rights was only designed to stop federal government violations. If you had a problem with your state, then you're going to have to sue under your state constitutions. Remember the idea of federalism. There's local, there's state, there's federal. Well, the federal constitution deals with federal actions. The state constitution is going to deal with state actions, but also local government actions as well. Now, that changed, and it took a long time, like, after the Civil War. And in some instances, you could argue that we're still fighting this battle. But through the 14th Amendment, now, if you've got a violation within the context of the first, 10 amendments, the Bill of Rights to the Constitution, then in fact, you can sue to have your rights protected under the federal Constitution. So it took the states losing a civil war in order to gain federal Bill of Rights protections to not only protect against federal violations, but to protect against state violations. Keep that thought in mind. The Bill of Rights only applied to the states until basically the end of the Civil War. Pardon me. The Bill of Rights of the federal government only applied to the federal government until basically the end of the Civil War. And then after the Civil War, what you'll see is that increasingly there were court cases and court cases and court cases, and different provisions in the Bill of Rights began now to be, the term is incorporated, so that they're covered by the federal Bill of Rights. Keep that thought in mind. Now, we're going to be dealing with a lot of First Amendment rights and things in these scenarios. So let me give you something that maybe you've heard about, might be a little bit more of an elusive term. And that elusive term is, in fact, the right to privacy. Now, let me say, y'all, and this may not make any sense, or maybe it will. There is no specific right to privacy written or included anywhere in the United States Constitution. Let me say that again. There is no specific right to privacy anywhere that is specifically written in the Constitution. But what the Supreme Court has done is they have created the right to privacy, or maybe the Constitution has hinted or insinuated that there is a right to privacy, or maybe the word that they've used in a number of Supreme Court opinions is the word penumbra. If you look in the penumbra of the amendments or the shadows of the amendments, there is an understood right to privacy that government is not supposed to be able to violate. Now, what amendments are these exactly? The first, the third, the fourth, the fifth, the ninth, and the 14th Amendments. If you look and you kind of combine the shadows of these amendments, well, you'll find a right to privacy in there. Now, one of the really good examples of a privacy case actually deals with contraceptives. Now, let me say, y'all, there's a number of laws out there that deal with sex, number of laws out there that deal with private matters, bedroom issues, that in fact states have passed maybe hundreds of years ago, and they're still on the books. And they're not ever enforced, so nobody really pitches a stink about it. But when they were passed, 100, 200 years ago, my goodness, these were big deals. And a really good example of this, y'all, is actually the contraceptive cases that came about 100 years or so ago. Now understand the state that was primarily in question here was Connecticut. And Connecticut had passed a law, y'all, that basically said that the government forbid doctors from giving prescriptions so that folks could get contraceptives. Now, part of this may have been religious. Part of this may have been that, when you get married and have families, you buy houses, you've got a bigger stake in the success of the government because it will deal with the protection of your own property, right? Your own lives. I don't know. But for our purposes, there were laws out there that banned the doctors from prescribing contraceptives. Well, there was a woman, y'all, that had a medical issue. So that in fact, if she got pregnant, then in fact, this could lead to her death. Let me say that again. If she got pregnant, then in fact, this could lead to her death. Now, not necessarily guaranteed by any means, but I got to be honest, if you tell me I've got a 25 or 30% chance of dying if I do a certain thing, then I'm going to be less inclined to do that thing. It stands to reason that a woman in that circumstance would be the same way. So she was concerned because, if she has sex without contraceptives, she could get pregnant, not trying to get pregnant, and that could lead to her death. So, y'all, she sued, and this case went all the way up to the United States Supreme Court. And when it went up to the United States Supreme Court, y'all, the Supreme Court dismissed her case. And the reason that they had done this was something that was called ripeness. Now, y'all, the Supreme Court, and we're going to talk about this a little bit later, has got a very strong ability to control the agenda of cases that they hear. They're only going to issue maybe a little bit less than 100 opinions a year. Not even all of those opinions are going to be written. They might just be summary dismissals of cases. But for our purposes, ripeness. And just think about fruit for a second. Have you ever eaten a green banana? It's not pleasant. I like mine a little less ripe maybe than most, but I'm not going to eat a green banana. I mean, it's bitter and it's hard and it's got all sorts of problems. Well, the idea is you wait for the fruit to ripen before you eat it. And the Supreme Court's idea is you wait for a case to ripen before they decide it. This woman basically said, look, I'm not pregnant, but if I did get pregnant and I got pregnant because the state had banned the use of contraceptives, then I could conceivably die. And the Supreme Court said, well, the Supreme Court said this case is not ripe yet because, ma'am, you have not suffered an injury. And since it's not ripe, since you have not suffered an injury, we are not going to issue a ruling on this case. Now, I got to be honest. I mean, if you're going to tell me that I got to go out and get pregnant and risk my life, hypothetically, if I was a woman, okay, if you were to tell me that I'd have to go out and get pregnant and theoretically risk my life in order to get a law struck down so that I would have suffered an injury. But technically, even at that point, the Supreme Court, y'all, was saying, if your concern is that you've died, if you come in here to court, you're not dead yet. The case ain't right. That's what they're saying. They threw it out. So they tried again, and they brought this to the Supreme Court. This time, y'all, it was a doctor. A doctor had said, look, I've got responsibilities to my patients. I've got responsibilities to my patients. And as such, if I see that there's a medical issue like this where somebody could die, I've got to take care of them. I've got the Hippocratic Oath. How could I live with myself if I didn't do everything I could to, in fact, ensure that they were going to be safe? Well, Supreme Court took a look at this case. And they said, doctor, they said this case isn't ripe. And they refused to issue an opinion. Why? Well, the doctor had not suffered an injury, and no patient had suffered an injury. Now, okay, let's be honest. And like I said, there are a lot of laws that are out there in a lot of states that were passed hundreds of years ago today that are not enforced in any capacity. Maybe even these contraceptive laws were not aggressively enforced. But again, if I can't get contraceptives and I could die if I got pregnant because I didn't have access to contraceptives, it would stand to reason that I would want to take this case to court. Well, they tried a third time. And this time the doctor actually, well, let me ask you, how is it that you could demonstrate that you had suffered an injury short of risking your life by getting pregnant? And understand, it takes time to get all the way to the Supreme Court, and they've already gone up there twice, and the Supreme Court said, we're not going to hear the case. Well, they invited a police officer this time. So the woman went in to the doctor's office. The doctor prescribed the woman contraception. And then, in fact, the police officer charged them with having violated the law. And the contraceptive case went all the way up to the Supreme Court. And the Supreme Court said, well, y'all got a ticket. Y'all have a fine. Y'all got some reputation out of this, some negative reputation. You've suffered an injury. We're going to strike down the law. Good God. I mean, the process of the Supreme Court, just strike it down. No, the court is saying it's got to be a real case. And if it hasn't risen to the level of ripeness yet, then we don't have to rule on it because nobody has suffered an injury. And when they were arrested, now they finally had suffered the injury. And it seems crazy that you'd have to go to the Supreme Court 3 different times over the course of years in order to finally get this struck down. Contraception, y'all, is a really good example of a privacy issue. And the Supreme Court did strike it down. And when you think about it, the belief quiz that I gave you dealt with bedroom and wallet issues. The bedroom issues were the things that you do behind closed doors, personal decisions, same-sex marriage, weed, abortion, these kinds of things, prayer. And maybe some of these would be more in the positive realm, traditionalists would say. Maybe some of these are more in the iffy realm, like traditionalists would say. Depends on who's doing them, I suppose. But the bottom line is that all of these things fall under this idea to a certain extent of privacy. Roe versus Wade, and I suspect that y'all have heard of this case. Roe versus Wade, y'all, was the original abortion case. And let me give you a second Supreme Court doctrine in this. Now, Roe versus Wade was really one of the cases where they were pretty explicit about this right to privacy. The First, the Third, the Fourth, the Ninth, the Fifth, and the 14th Amendments, within the penumbras or the shadows of these amendments, granted you a right to privacy. Well, before they got there, I'd asked you that before, do you eat, green bananas? Do you eat rotten bananas? Well, no, right? I mean, it's disgusting. You wouldn't eat rotten bananas. Wouldn't even make a banana split out of them. Well, sometimes a case resolves itself before it gets to the Supreme Court. And just like if a case has not ripened into a controversy, the Supreme Court will not hear it. If a case has resolved itself before it gets to the Supreme Court, then the Supreme Court won't hear it. One of the things that Texas had argued in Roe versus Wade, and this is actually a pretty interesting argument if you think about this just in a very matter-of-fact way, they said that the case was moot. Now, moot means that the case has already resolved itself. And when you consider that Roe had already had the baby, that in fact she was suing to abort, technically, the case had resolved itself. The Supreme Court could very easily have not created the right to an abortion in Roe versus Wade with the right to privacy by saying that this was a moot case. However, they did not. And what they said was in fact that you think about the process. If it takes over a year to get to the Supreme Court to get your case heard, but it only takes 9 months. We cannot have a biological reason, a biological necessity being the reason why a case doesn't go to court. So what did they do? The Supreme Court said that there are millions of other similarly situated women at the United States at a given time. Similarly situated meaning pregnant. And so they threw the mootness argument out. And in fact, they did allow in Roe versus Wade, they allowed her to establish this right. Now, maybe you've heard of the trimesters, and I'll be fairly brief with this, but the idea behind the trimester system is effectively this. In the first 3 months of a pregnancy, a woman basically under Roe versus Wade has complete control to decide what she wants to do. Y'all, there's an old term in history that's known as quickening. And quickening is the idea when the baby, the fetus, would first move inside of you. And the idea is that they have been given the breath of life, taken their first breath in a metaphorical kind of a way, quickening that first movement. There is a sense there that that's when life begins, at least in a historical kind of common sense, not necessarily an official medical one, but in a practice, in a belief sense. That typically happens at about the 3rd month. So the idea is, in a more medical sense, is that the fetus cannot really live outside of the body of the mother. At least it could not have been as readily able to do that at the time of Roe versus Wade 50 years ago. So, in fact, guess what? The woman's got complete control. Life hasn't happened yet. That would be one of the arguments. Now, the second trimester, it begins to change because that breath, that quickening, that first kick, if you will, of the fetus has happened. So now this fetus has become more viable to be able to live outside of the woman's body. And as such, while the woman still has the dominant control over what to do with her body in the context of an abortion, the state now can prescribe some regulations. So what you're going to see progressively is, as this trimester system occurs, 3 trimesters, well, the first trimester is almost exclusively the control of the woman. The second trimester is still largely control of the woman, but now the state begins to be able to exercise some limitation on this. And then when you get to the 3rd semester, this is months 7 through 9, even in Roe versus Wade times, the fetus would be viable as a baby outside of the mother's body. So as such, the state now is going to exercise more control. And typically the health and safety of the mother, or maybe the health of the fetus. And I mean, maybe if there was a serious birth defect or something along these lines, a precondition, well, at that point, then the woman would have more of a decision to be able to decide what she wanted to do. Now, this was the structure that had lasted for a really long time. And like I said, they overcame this idea of mootness by all of the similarly circumstanced women. And they really began to build on this notion of privacy. Now, funny thing happened. If you rewind the clock, over 50 years now, what you'll see, the analogy that I use for this, y'all, is planting a tree. If you wanted to plant a tree, right, in your backyard, you could plant it today. If you decided that you wanted to dig it back up and replant it somewhere else in a few days or a few weeks or, maybe even a few months, I would reckon that that would be pretty easy to do. However, the longer that you leave that tree in the ground before you decide you want to remove it, guess what? The harder it becomes. Well, imagine, y'all, if you planted a tree and you decided that you wanted to dig it up 50 years later, how difficult would that be? I mean, I don't know that you could dig it up and replant it. Not without some heavy equipment and some cranes and a lot of patience and a lot of people power to do. Well, that's what happened when you think about the Supreme Court as they make decisions. And one of the other doctrines that you'll see that the Supreme Court has, y'all, and this really does have a strong relationship to this context of abortion, is the idea of the term stare decisis. Y'all, stare decisis is the idea of let the decision stand. And it literally means that if the court makes a decision, that in fact, under the doctrine of stare decisis, if future cases come up that have the same circumstances, if future cases come up that have the same issue, then the court should stick with the earlier decision, not break the tradition. And if they do it, well, they're going to do it on a pretty new case. You think about Obamacare, the Affordable Care Act, right? How many times have the Republicans taken that to court? Why? Well, they took it to court because they knew they had to get it early if they were going to get it. And did they get some wins? They did. Did they ever get it all the way struck? No, they didn't. And now we're getting to the point where we're years away, a decade away from ACA becoming law. It's not likely that that's going to get struck down. Well, when you talk about abortion, y'all, you're talking about stare decisis over the context of 50 years. I don't know that I really ever thought that that was going to get struck down. And, what happened after Roe versus Wade? Well, in the aftermath of Roe versus Wade, the Republicans began to look at things in terms of the context of the United States Supreme Court. And, you can amend the Constitution to get rid of abortion. But if you remember, you're going to need 2/3 of the House and 2/3 of the Senate just to propose it. And then you're going to need 76% of the states, 38 of them, in order to be able to ratify it. That is the proverbial ice cube's chance in hell, because that means that there are going to have to be some Democrats that join with the Republicans. And I just don't see that happening. And in fact, it never did. Well, if you consider the Supreme Court, and let's just say that these blue X's are Democrats on the Supreme Court, and let's say, y'all, that these red X's are Republicans. Ronald Reagan was somebody that actually came up with the idea. And Ronald Reagan basically had said, look, all we have to do, we don't have to get 2/3 of the House and 2/3 of the Senate. We don't have to get 78%, 76% of the states. We need to get a majority of Republicans that are, in fact, on the United States Supreme Court. In other words, if we can turn a few of those blues to a red, or better yet, maybe if we could even get another blue to become a red, these 6 justices are going to be able to be the ones to be able to change this law. Reagan started this, and he and Bush daddy, they had gotten to the point where basically they had 6 or maybe even 7 sometimes conservative justices on the Supreme Court, but they never overturned Roe. When Trump ran for election the first time, and let's be honest, Trump may be a Republican. I don't know that he is the most traditional conservative Republican, though. And in order to win over some of the more religious folk, what did Trump do? He actually put together a list, y'all, of Supreme Court justices that he would nominate to the court. He put together a list of federal judges that he would nominate when he nominated judges to the Supreme Court to replace those Supreme Court nominees. And he demonstrated with this list that, in fact, these were going to be people that were going to be anti-abortion. Now, is Trump responsible for Roe versus Wade getting overturned? I wouldn't say that he's responsible entirely, but did he help? Well, he did get these conservatives on the court. And in fact, these conservatives did actually strike it down so that they never needed 2/3 of the House, 2/3 of the Senate, and 76% of the states. And y'all, if you go back and you look, and bear with me as I change my screens one last time, just a few years ago, what did you see? You saw Dobbs versus Jackson Women's Health. And this was the case, in fact, this was where the Republican majority on the Supreme Court actually struck down the right to abort. Now, this is important. And let me say this. And you remember at the beginning when we had started this, right? I had mentioned to y'all the idea that the federal Constitution only applies to state violations because of the 14th Amendment. So at the beginning of the country, the federal Constitution only dealt with federal violations, but state constitutions dealt with state ones. Well, when the right to privacy explained through Roe versus Wade and other abortion cases in the aftermath, When that was recognized by the federal Supreme Court as being in the United States Constitution, that meant that the federal government could step in. However, now, in fact, that they have struck down this right to abort, at least this federal right, abortion is now in the hands of the states. So let me stress, is abortion illegal now? No. Is it a federal right now? No. And since it's not, that means that the states get to decide. And that's why you see how some states almost immediately banned abortion. You see how some states actually set themselves up. Maryland, and this is kind of an odd look. I get it, but it's still odd. Maryland has kind of set itself up as an abortion tourism state where they are welcoming people to come here to get abortions if in fact they reside in a state where abortion is not legal. So understand, states are now free to decide. You'll see where some states are offering significant funding. You'll see where some states have got, fairly significant protections. You'll see where other states are not just banning abortion, but they do not want, they'll even charge people in some instances for driving someone across state lines to get an abortion. So understand this is more of the wild, wild west now. And, the federal rights are interesting. And I'll close with this in this video. When the federal government grants a right, they guarantee a right, they protect a right, whatever word you want to use, like privacy, like abortion, that means that one size fits all. I don't know if y'all are McDonald's people, but one of the comforting things about a McDonald's is no matter which one you go to, you're basically going to get the same thing. Okay. You know what you're going in there to get. You're not going to get surprises. If you think it's good, it's good. If you think it's meh, it's meh. If you think it's struggling, it's struggling. But you know what you're going to get when you go in there. When federal right is involved, you know what you're going to have no matter where it is that you go in the country. When abortion was struck down, now you don't because states are free to decide. And y'all, this is another example of where federalism isn't just as simple as going to the grocery store and seeing where your fruit comes from. This is an example of where you could be facing a very different law or the absence of a very different law, depending upon which state you're in. I'll stop there. Thank y'all.